you all can from your place and introduce yourself. Just tell me your name and your from which faculty. Can you start for me?
Hi everyone, I'm Eugene from Graduate Business School. Hello, I'm Paul from Institute of Music.
I'm Steve from Institute of Music. Hi everyone, I'm Yvonne from School of Architecture.
Jeff from FBN. Meg from FBN.
Thanks everyone. Today, what I'm going to teach not to say teach, I'm going to share my knowledge. What is the differences between MOU, Memorandum of Understanding, LOR, Letter of Intent, and Agreement. Okay, most of us call agreement as an MOA. You know, everyone's understanding like what I noticed from past 10 years. Agreement means MOA. People only know agreement means Memorandum of Understanding. Memorandum of Agreement is just one of it. Agreement, there are various: student exchange agreement, non-disclosure agreement. But generally, people understanding agreement means only MOA. Okay? So today I'm going to tell you what are the differences. How many of you involved in doing agreement or MOU or LOI in your faculty? Generally, most of you, because usually I will get emails from most of you. Okay? Now, today's learning objective is: first part, I will teach you understanding the legal framework, letter of intent, in short form we call it as a LOI, memorandum of understanding, MOU, agreement or contract, MOA, memorandum of agreement is part of it. Okay? And then I will going to teach you second part, understanding the university governance. What is the university structure and also university constitution? How many of you know there is a university constitution for our UCSI University? Okay. Not only for UCSI University, all the universities has their constitution. That's a main governing document. Okay. So far so good. So today's objective now. Okay, first part. What is the first step when you want to enter into either could be LOI, MOU or agreement? What is the first step you will do? You already identify your partner. Is it straight away you will negotiation with your partner. So why you need to do that? So you can understand, so that you can understand whether both party intention are same. If intention are same, then we can bind together, we can sign the agreement. If different intention, we cannot get along. Okay? Still you proceed, even though different intention, still you proceed to sign, what will happen? This dispute. So we don't want that dispute to happen, right? So that's why we need to negotiate first whether the terms, condition is fine with both parties. Okay, that's the first step. After the negotiation, what you will do? Due diligence. Due diligence means, how many of you know the word due diligence exists? Okay, good. How about others? Okay, can Miss Patti tell me what is due diligence? Just what do you understand? Very good. That's the right answer. Due diligence means you need to check your partner which you are going to enter into a contract. But how to check? How you know whether they are telling truth or not? Of course, by asking verbally, they will say, I'm the best university, I'm the top ranking, right? They will say they are the best. Financially, they are stable. How usually you can do that? I know that some of you asking for some document. What are the fundamental document? Whether they exist or not exist? Just Google. Yes, Google. Even Google messages also not accurate. Okay. Due diligence means checking other partners' capability, whether they are financially okay. Just for example, if they are not financially okay, when you sign with them, then you have to fork out your own money in order to fulfill the obligation. Okay. Next. The third, okay, this is a brief explanation only. Just to the point before that, check the financial. This is just a brief explanation. I will go into that. Okay. Next, okay, once you already checked their financial capability and also whether they have any legal dispute with other parties, everything checked perfect. You feel okay, this is the right party, I can enter into contract with them. Then the third, then you identify key terms. For example, you want to enter research collaboration agreement. What are the key terms you want, conclude with them? That's the third. Some of the terms, for example, duration, termination, warranties, now all those are standard. But only your part, you need to come on with the scope, purpose, obligations. Okay, those are the clauses you need to discuss. You need to discuss and come to a conclusion with your partner. Sometimes, first step, yes. Second step, yes. Third step, when come to a example, payment term. You want them to pay within 3 days. But they say, no, only after 30 days. Then you cannot come to a conclusion, you have to let go the partnership. So, then the third process is identify key terms. Okay, first one, yes. Second one, yes. Third one, yes. Fourth one is the final process, Dr. Vanil, it's you smart. I know you know. Okay, drafting means
To get the initial agreement out with all those terms that has been agreed.
okay. Reviewing,
Reviewing is to go through again to ensure we use the right words, legal words, at the same time to ensure that all the terms are actually agreed and the proper duty has been done.
okay. Okay, Miss Parveen, reviewing means what? Okay, drafting means, okay, after you conclude the third step, there's purpose, scope, obligation, and the duration, like 3 years or 4 years, how the termination clause should be, like 30 days notice or 5 days notice. Okay, drafting means from scratch one party will draft or use the existing template, they will fill in the blanks. That's a drafting. Once, for example, UCSR University once draft, then they will send that draft to the other side party for them to check. Reviewing means your partner already has the template, so you no need to do from scratch. They will send their template for you to review. So you need to check. Because only the licensed person know what are the items discussed, right? So then you need to check whether the payment is right or the terms is right, duration is right. So you need to review it. Can understand? Drafting means you draft from scratch. Review means other side party will give their template and you need to review. There is another meaning for review, which Dr. Benedict and also Miss Parveen say. That's a review, like another meaning of review. So legally, drafting means you draft, review means from other party. So that's the difference. Okay? So far so good. Okay. If we already have the existing template, like our MOU, once you insert all the details, then you need to send to the other side party. That's a drafting. So once they confirm, then the final one I will check. For the reviewing, the other side party template, right? They will send to you. You need to check. Once you need to check not on the legal part, on the operational terms. Only the operational term. Then when you send to me for my final writing,
Sorry,
say
I rephrase my question. When we want to enter into a so-called contract, right, who initiates the drafting? Is it which party?
that's up to the license, how you all come to a conclusion. It's up to the parties. You can tell, I already have the existing agreement, which we already entered with another company, we already has the template. So that's not a fundamental rule. Up to the parties.
I asked the question because of the risk that's involved. For example, if the template comes from outside party, whether we have the competency to actually review it or not.
Oh, that's why I'm here. That's why legal department is there. No. All the terms which I'm going to show to you is a universally standard. Only the purpose, scope, obligation will be different. Termination is termination. Only thing, the notice period or after termination, what will be the obligation of the party? That's the difference. Okay, right? So far so good. Okay. Now, why due diligence? Out of the 4 steps, due diligence is the most important. I'm going to give you a case study. Okay, let's read this case study. I'll give you 2 minutes. Okay? That's ready? Okay. Can I understand? Okay, now. Will the financial and legal issues of ABC University affect UCSI University? Yes or no? Okay, yes. Hadi say no. Come. Brave man say no. Okay. So the answer is yes. How? Okay, let us see how it will affect. See, delay payment for joint research expenses. So we have to incur because we want the project to be completed, right? Next, then when we partnering with problematic partner, so our name will be tarnished. When our name will be tarnished, definitely ministry will send us a letter for investigation purpose. Who will receive the letter? The project owner, the researcher from UCSI University? Who? Who is the management? Not the legal. Okay. Definitely not me. Yes. BC. Why? Okay. She is the signature, but actually not that. That's one of it. She is the registered person under the Ministry of Higher Education under Section 31 Act 555. All of us can do anything, but she's the only person answerable. Okay? Ministry will send letter to her. Okay. Next, how can UCSI University avoid the situation? How? Time to discuss. Yes, due diligence. Okay. As I know, all of you are experienced person. Just tell me. Okay, like Miss Parveen says she will Google. What other ways you all have done before this? Okay, one is loss. Definitely. Okay, or call ministry. Just tell like what you all have done must be license. So you should ask the university license. Okay, that's one step. Finance? Yes, audited accounts or their P&L statement. Legal cases? Some legal cases we can Google, right? Famous legal cases, then we can Google. If not, then we need to go to a proper website. I'm going to show all those, okay? Now, okay, very good. I'm happy. Okay, those are the things we should do first before we enter into a agreement with other party. Alright. Okay, let's see.
Really, I have a question. We enter into MOU and OA with a lot of partner universities and all that. Technically, as a faculty, we don't go and ask for your registration license and things like that. So, is this something that you do at your office or what? Because we don't do this kind of thing. Although we do inside visit on that university, we check it out, we talk to people, we know that we are looking at the financial report or the license and all that, we don't, and legal cases and all that. So the question is, does UCSI, your area or who does that, or is it supposed to be us doing it at the
Okay. Proctor asked me who will ask for those documents.
No, who does that checking for
Oh.
UCSI?
Okay. For the actually liaison person, Doctor.
But how does a lawyer, you need to be actually, maybe your financial
No, financial report you won't release easily unless you enter into NDA. But when you will come to this stage when you sign a contract with them, when in MOU stage you can ask for SSM registration. SSM registration or university license is a fundamental. They will give only the Borang 9. Borang 9, I'm going to show you why. Borang 9. So it's a confirmation they are registered under the SSM.
How about international university?
License. Their university license. Usually they will give. Same goes to us, they will ask us also. They will give, we also can give to them. Yeah, license, the license person. Is it genuine? Yeah. Good question to ask. Okay. Usually, with the license person will get confirmation from the ministry for their big projects. That's how usually they will do. MOU related. Just an SSM will do. Be SSM applicable for the company, for the university is the license.
From what I understand, there is a preliminary information on potential collaboration form that our global engagement office uses to investigate and do due diligence. That's what I know. But I'm not speaking on their behalf. They are not here.
Actually, that's created by us. It's in the ISO document. It's an ISO document, but not in practice for some time already. During Mr. DD time, every time they will do that. But eventually, like now, no one is practicing it. We have that.
We don't have a standard template. We don't know what to check on, how to check.
We the share detail are the one they won't release until you sign an NDA. But when you need to sign NDA, when you enter into a agreement, contract which involve huge sum of money. Okay, so when you sign, why you need to sign NDA? NDA is for non-disclosure agreement. So they are going to give you all their confidential information. So when you sign this, you suppose not to disclose that confidential information which you receive to other third party. Okay? MOA is agreement means there are so many memorandum of agreement is one of it. It's one of the name. See, that's why everyone confused. Many people think agreement means only MOA. That's not. See, we have student exchange agreement, collaboration agreement, and non-disclosure agreement. I would say not necessary unless you research involved a huge amount of money, then we can ask for their financial resource. Small amount of money, but you just make sure they are legally exist. They are legally exist. Okay?
If let's say we are collaborating with Oxford, Cambridge, Stanford, which we know so established, we still need to ask them. Can we see that or what? Sorry. If let's say I collaborate with Cambridge, Oxford, we know existed founders of this and good reputation. Do we still say
generally people don't, because we know they are already established institutions.
So we are just assuming.
There is a checklist, but depend, if you just big institution. If you want to enter into a small company, you don't know what you're doing, right? I'm just sharing. 3 years ago, we entered into a contract with a company, but this is not university related. This is different. So we entered into a wrong party. This is ongoing now. We entered into a contract with a wrong party, which is a scammer. It's a real scammer, and he is suing us now for 16 million. 16 million. So at that time, everything in a rush. So we never do the due diligence. If he did, then we will know he has a lot of court cases that he's trying. Even just last week, in one of the main newspaper, he sued Menteri Besar Kedah. That his trend. Same thing now he's suing Dato' Peter. So, but scammer, we know we are scammed by him, but legally the company exists. So he's happy to enter contract with huge institution. Then he will find some loophole. He will terminate and he will sue. Okay, so those are the implications. There are so many cases I cannot disclose. So I'm we should know. So we will get all the documents. That's the
But there are exceptions, right? When people come to visit us and then we discover they don't have a university.
yeah. No, supposed to go for audit, but that particular case, people went for audit. But everything is depend on the liaison person how they initiate this project. Actually, even for the established university, if we want to ask, we can ask. No harm, they will provide. But if you have a confidence as an established university, we know it, then up to the project owner. Okay? But it's good for us to ask. Okay? So, those are the link you can use to check for the company SSM whether the company is registered company. Then you can check from that link. Who know how to check company number? Many people. Can. Company number is the fundamental. people confuse between SSM, business, and also license. This is UCSI SSM registration document. This is how it looks like. Initially in 1989, UCSI registered as Sedaya College, and eventually in 2000 something year, it changed to UCSI Education Senja Berhad. Until now, it's UCSI Education Senja Berhad. 2003. Okay. If you can see, this is Borang 13. Borang 13. Borang 13 means Form 13 only use when the original company change name. If the company still same name, Form 9. Form 9. Okay? If they change name, then they will use Form 13. So currently we are using Form 13 because we changed our name. Okay. University license. Another word, permit. Permit to operate university. Okay. Pelakuan pendaftaran in Malay we call. Okay, it's valid until 2028. Okay, so you all know the differences between business registration is registered under business registration under company commission Malaysia SSM. SSM license issued by Ministry of Higher Education. Okay. See, if we want to form a company, where you register your company? With SSM, Companies Commission of Malaysia. Okay. The other one is the university license. Who will give you license to operate university? Yes, Ministry of Higher Education. Okay? Okay? Okay, huh? Okay, now, everyone's question, most of the people's question, is the university company? Okay? Is the university a company? Yes. Okay, I rephrase my question. Is a UCSI university is a company? No. Okay, no. Honey, I know you pretending, you holding your head. Okay? Yes or no? Okay, no. You know what's my question? Yeah, okay. Dr. Meredith?
No, it's not.
No. From? Is a UCSI university is a company? Okay. How about you? Yes or no? No. Yes or no? No. Yes or no? Yes, the answer is no. UCSI Education System. Oh, the answer is already there. That's why initially I said yes, suddenly no. Okay. So UCSI Education Sendirian Berhad. Sendirian Berhad means private limited. It's a entity. It's a company. UCSI University is compulsory to form a company. Once the ministry given you approval to operate the university, within a year you must form a company. Section 12. You must incorporate the company locally within a year. Otherwise, the approval will be cancelled.
So like UCSI school or
UCSI school, Secondary and Berhad, they have their own company. Each college, UCSI college, Secondary and Berhad. College has their own company.
Is my college only? So college has their own company.
School, hotel, every businesses which owned by UCSI has their own company. Only university, no other business. This is education. No business. Kuching has their own license. KL campus has their own license. Springfield under the KL campus is a branch.
Is there a point Sarawak because since we do not
I think they have their own reason. I will tell you later. Okay. Okay. The one who own license. Group. Okay. UCSI Group Sindri and Berhad. You all know, right? There is a company called UCSI Group Sindri and Berhad. Group is the holding company of all the company, like a parent company. Parent company.
So education is under
Under all the company, UCSI Hospital, UCSI Hotels in Berhad, UCSI College in Berhad, UCSI Extension.
separate registration and
Each subsidiary is
so
yes.
hospital is a registration company.
Yes, group also.
Then the group also one.
Yeah, my own group.
Then it is
It's a parent holding company.
so it's public listed, right?
No.
so then
Then what we have foundations in
We are not public listed. Yeah, I'm going to group holdings in Berhad. This is the registration number. We formed it in year 2010. Year 2010.
So under this will be
All the companies.
all the others never have.
This one is parent company. The rest of the companies all are kids. Okay, we have 23 companies. 27, sorry. legal person. UCSI education is a legal person. People can sue UCSI education, but people cannot sue UCSI university because it's not a legal person. Can sue, can be sued. Okay, that's the main purpose. Actually, Ministry of Higher Education is. I attended that course. 5 years ago they wanted to amend the act, but still it's not happening. Okay, now test your knowledge time. Easy questions. Okay. Actually, I have a surprise for you, for all of you. Check your chair. Here, this part. I came here at 7:30 to do this secretly. Just take and keep it yourself. Oh, you know, the person, right? Always liaise with the partner. So the liaising person column will be that person name, not PC's name. Some people will put PC's name. PC not a liaising person. Or they will ask me, I'm also not a liaising person. Project the person. It could be whoever. But provided that person has knowledge of that ongoing. They know what's going on that project. That's the main thing. Okay, next, license person. Okay, we go one by one now. Sir.
So what I got here is assignment.
Assignment.
Yeah, so if
Not an assignment.
yeah, individual assignment and maybe from the context of legal, and also this MOAs. Yeah, it's assignment, which is could be the transference of the obligations or responsibilities, from one party to another.
Very good. Yeah. Right. So assignment means you, if it's a simple legal word, you assign something to other people because you cannot fulfill the obligation. Because sometimes, so whatever you have been, you have come across, because every time you when you bring any MOU, whatever agreement, you will come across this word. So you are assigning your duty and responsibility to another party. So legally it's allowable, provided you put in the document. If you not put in the document agreement, then you cannot assign your duty. Whether you like it or don't like it, you have to complete. Okay?
Good morning, everyone. Mine is intellectual property rights. So it is protecting your own original ideas from stealing. So others don't steal the ideas, and also monetizing your ideas because you can sell them, your prototypes, your inventions, and also your ideas.
Intellectual property rights. Okay? Give me like one example. Start from C. Yes, copyright. Another one. TRA. Yes. So those are the babies of intellectual property rights. So that's the biggest heading. Like copyright, trademark, subheadings. Okay. Next,
Mine is on confidentiality, so this means that we keep secrets, whatever that information that is disclosed to you, we do not disclose to anybody who has no business
very good. Correct. So confidentiality is a common English word, confidential. Okay. So you must keep confidential of the project. Okay. Cannot after you sign agreement, cannot the next day you post in the social media. Okay. I signed with these people so and so. Unless permitted. Okay. And your chair was not shared.
the person that signed, witnessing the person that's signing the contract. So there's two parties that signing any agreement or contract, but there's a third party that witness the right person that's signing the both contracts.
So, what is right? Okay, witness is a person, and witness is a person who witnessing the person signing. Okay. Legally, can husband witness wife's signature? Okay. Because legally, husband and wife consider one person. Yeah, under the Family Act.
Okay, I got the word term. I think this is a little bit similar to roles and responsibilities, right? But then the difference is that maybe there's like extra things that you want to highlight that's not in the roles and responsibilities that's like extra, right?
It can be duration.
Oh, okay.
Duration of the contract. So you must have a duration of the contract. Okay? Can the duration be infinity? Perpetual? Cannot, yeah? So you must make sure 1 year, 2 year. Okay? Yeah, like duration usually they will say that, there's no standard you can amend by the meaning of the duration is how many years. So you can, this MOA is valid but perpetual usually people don't sign. Why? Because any changes happen then you cannot review. Then you have to mind. Perpetual is forever. Forever until the company exists. We cannot sign.
I receive termination. To me, this word is end of something. It's bad for something.
So the relation is end of the partnership. Okay? Sometimes happy ending, sometimes sad ending. Sad ending, we will see you in the court. I will sue you, okay? Dr. Delaney.
Mine is force majeure. It's a French word. It's a French word, majeure. Force majeure. You don't pronounce it E. But we in Malaysia we say force majeure. So it is forceful closure owing to the act of God, meaning earthquake. And I used to use this term during in my class when the time to submit their various assignments. Only when there's force majeure, you don't have to submit. So there is earthquake, war.
Okay, in 2020, everyone used this. Why? What happened in 2020? Act of God, COVID. Okay? During COVID time, people didn't know about this clause. So now they know the importance of this clause. Okay? It's an unforeseen event which is beyond our control. The act of God. Okay? Next. people will know what is the purpose of you signing the agreement. That's a fundamental. Okay.
I have roles and responsibility, so I assume is going to be what you are supposed to do. Each one of us plays a certain role that is in so as an initiator or as a liaison or as a somebody who's in charge of the
Okay. So one word for this start from O. O B. Yes, obligation. So obligation.
Hi, my word is scope. Scope. Scope means the boundaries of which things that fall under the contract. It's like the boundaries.
So what you are focusing on? So after the purpose, then you must come on with the scope. Like purpose, and sometimes people will say purpose and scope. Okay, what you are going to do? Miss Parvi?
Liar. She can use this.
Mine is governing law, so I've seen this on the MOU templates. So I assume these are the laws that the parties will be obeying, especially when there is a dispute in which law, so they put demolition law or whatever. I think so.
So governing law means, for example, I'm from Singapore and you are from Malaysia, then party need to decide which law the agreement they want to govern under which law. It can be both countries' law, but some people they want third country, for example Hong Kong, like different country law to be governed. So later we will see what is the disadvantage if different country law to govern. Okay? Okay. Two countries law, and then when it comes to a dispute, you must reserve that where the dispute occur. Sometimes it will happen in Malaysia or sometimes it will happen in Singapore. So then the jurisdiction will be where the dispute happened. When something happened, for example, the student travel here, then accident in Malaysia, then the Malaysian law will happen. So the dispute, we can use Malaysian law because we are the affected party, right? We will initiate the case, not them. We will initiate because the dispute happened. Dr. Loh?
Means that you're not bound by any because it's usually spot for you, right? When there's no financial
Okay, Dr. Low one is non-binding. Non-binding means you are not legally responsible to fulfill your obligation. Okay, you can promise you will do certain things, but not necessarily you have to do because it's non-binding. Okay.
My word is actually opposite of what experience is about the law. My word is binding. So it's just that you are required by the law. Yeah, I got experience. Required by the law to fulfill the responsibility.
Exactly. So, must fulfill your responsibility. Okay.
Mine is jurisdiction, so I believe it's similar to authority who has the power to decide or judge.
Same. extension cord or Singapore cord. So up to the parties.
Signatory. So which party?
Okay, signatory is the signing party. Okay, Dr. Fatima one is amendments. Okay, amendments means what? Okay, we already signed the agreement. Okay, but suddenly some changes. Then that clause will allow us to make the amendment. Okay, so then with the consent of both parties. Okay, we cannot simply amend. We must discuss with the other side party. Okay? So the parties who are in the agreement. Okay, party A, party B. Not the party.
The reason a different agreement because some usually want to be party, but usually when we take them out of template, we say sign party, right? Doesn't make a difference.
Actually, no difference. It depends on the party. Sometimes they want to be the first party. So actually, no difference.
What is exclusivity? So my understanding, there is a legal contract between two parties, and one party is restricted not to sell the products or to another to certain purchaser for a certain period of time.
Okay, exclusivity means you are not allowed to sign for the similar project with another party. Okay, so it's exclusive.
Everyone, so I have payment terms. I think it's the duration and condition for the buyer to pay, like what installment, credit payment.
Also the how much? Thanks. Any more? Actually, okay, thanks a lot. So what I can say from the knowledge we are shared, everyone knows fundamental understanding of the terms and conditions. Okay, so easier for me to explain it now. Okay. See, what are the common clauses in LOI, MOU and agreement contract?
Before you go into the
Oh, is it? Okay, letter of intent is the non-binding letter. Both party, for example, both party want to intend to enter into MOU. So before they want to formalize enter into MOU, they will discuss. Okay, we discuss first. After a month, we will enter into MOU. So they will list down what are the topics, items they want to discuss. LOI, letter of intent, intention of the party, they will write in the letter. And they will discuss. Then they will enter LOI. No, LOI is between the parties.
Is the LOI from us?
No, it's not a must. MOU. Okay, passport number or IC number when you enter a contract with a person. Sometimes we will enter a contract, micro-credential agreement is between UCSF education and also the lecturer, because it's a partner lecturer, right? So, you must know their IC number. Okay, you must get their IC copy. Okay, because we are entering contract with them. Okay, and purpose and scope. Okay, you must outline what is your objective, purpose of the agreement. Next, term and termination. Term means duration. How long you want to have that MOU or MOA? 1 year, 2 year, 3 year, 5 year. Termination, you can terminate the partnership with your partner, provided you must give a notice period, 1 month or sometimes 7 days. So everything you must specify. Sometimes with reason, you must give a reason for termination. Sometimes you can terminate without a reason. You don't need to say why you are ending your partnership. So if you specify, then it will be easier for you. If you not specify, then it will be dispute. Sometimes they will ask why. Because, roles and responsibility, parties to discuss. Then, roles or obligation of UCS education, obligation of ABC University. For example, if any collaboration, UCSI education must provide 16 hours lectures. Another obligation of ABC University, they must provide space to conduct the lecture, something like that. Okay, intellectual property means is in short we call as an IP. So is your own work. You need to protect your work. Okay, you must register your work. So intellectual property right is the word underneath copyright, patent and trademark. Copyright is your literacy work or your musical work or your artistic work. Patent is your inventions. So you need to know the differences. Trademark is your logo, names, slogan or any symbols. Okay.
Can I ask one thing? Let's say for somebody, we usually have a project with community, where we have companies that let's say we will go kampung. So usually we like with the go kampung, let's say. So and then we want to do a long-term engagement with them. So how do we do it? Because
use. Start from P. Please, okay. You cannot say to police, yeah, I signed NDA already. No, they will bring you to the lockup. Okay? Because you are not cooperate with them is the offense. So you must cooperate with them. Okay. Next, payment terms. Payment terms, you know. Okay? Any contract we sign, the fundamental part is payment. So everything you must clearly spell out. Like you say, if you want to have an installment payment, you must list it out clearly. Okay? Because the main dispute will have start from payment. Okay? Police is the authorized person or any government official, but they must be with the authorized order. Okay, warranties and representation. Okay, you did the due diligence, right? Okay, if even you did the due diligence, something goes wrong, you sign with your partner, but if you have this clause, your partner is warranting you, yes, I am legally can enter a contract with you. If they lie, then you can use this clause to sue them. They are warranting you. They are legally representing company. We have all the rights to sign this agreement with you. That's the clause. Even though your due diligence goes wrong. Okay? That's the representation and warranty. You giving assurance you are authorized person to enter into a contract. Okay? Governing law and jurisdiction. Okay. Many people, this is the common question and always people don't understand. Governing law is, okay, if you enter into a contract, you must specify in your contract which law you want to be governed. Why? If anything goes wrong, then you must follow that law. Malaysian law means you must follow Malaysian law. Singapore law means you must follow Singapore law. China law means you must follow China law. But if both companies are from Malaysia, it's advisable to follow Malaysian law. Some people, they will, they want other country law to be governed. But what is the disadvantage? For example, Singapore law to govern, but both countries are Malaysian law. Malaysian country, dispute happen, you have to bring to Singapore court. Singapore court. You need to hire a Singapore lawyer. Malaysian lawyer cannot represent you. So you will have a bond. What bond? Legal cost. It's not that cheap. Okay? So that's why you must make sure the governing law is either Malaysian law or both countries' law. If you put both countries' law, for example, your partner is a Singaporean partner, you can put both Malaysian and Singapore, but dispute where the dispute occur, then that country law will be applicable. Okay, you must make sure you must put that clause. Then, if the dispute happen in Malaysia, then we can bring to Malaysian court. If the dispute happen in Singapore, then can go to Singapore. Okay? Jurisdiction. Jurisdiction means which court has the authorized or jurisdiction to hear your case. For example, for holiday, you went to Malacca. You are staying in report in KL? Okay, what the police will say? Yes, go to Malacca, do a report there. Why? Where the dispute or accident happened? In Malacca. Malacca is the jurisdiction to hear your case. So you must go there, you must lodge report there. If any summon or cases, you must go to Malacca Magistrate Court. So jurisdiction is very important. Okay? UCSI University is under KL jurisdiction. So anything goes wrong, must go to KL High Court. Okay? Yeah, I want to ask one question. How many federal courts do we have in Malaysia? How many federal courts? One, 2, 3, 4? Or each state one federal court? Federal court, one. Okay, one? Sure? If Lillian saying Sabah Sarawak got one federal court. No. How many federal court? 3. Only one federal court we have. Okay? How many parliament do we have? One. Okay, one. Adik, setiap state ada parliament tak? How many parliament kita ada? This answer is one. Okay, it's parliament one. How many parliament do we have? Okay, one. Okay, how about okay, one. Okay, how many parliament in your country? Okay, parliament also one. Okay, who's the one? Okay, parliament or federal court is one. Okay. Our courts are Magistrate Court, Session Court, High Court, Court of Appeal, Federal Court. Magistrate Court can hear both, actually all the courts can hear both criminal and civil. Magistrate Court for civil only can hear up to 10,000 ringgit. 10,000. Okay? Magistrate Court cannot give death penalty. Cannot. Death penalty. Session Court 10,000 to 1 million. If your claim is 50,000, you cannot go to Magistrate Court. You cannot extend go to High Court. You cannot. Must go to Session Court. Okay. So Session Court also cannot give death penalty. Only High Court can give death word is appeal. Here appeals. You cannot bring a new case to Court of Appeal. Court of Appeal only will hear your appeal. Appeal is like appeal is a common English word. You go appeal. Anything you are not happy, appeal. But magistrate court decision cannot appeal straight away here. No. Must go here, must go here, must go here. Cannot straight away. Cannot. Okay, session court must go here. They must give permission to hear your case. Hear your case, still not happy. Still, death penalty, appeal here. Still say no, death penalty, appeal here. After say no, still death penalty, where you go, where you need to appeal. Okay, the one is for pardon now. So, still you are not happy, death penalty, the judgment is yes, no, death penalty. Wait for your day to hang. No other avenue. Last time, yes, can go to world court, but now Malaysia closed it. Yeah, things pardon. You think that easy? Everyone will get no. Okay, so you count your days, pray. Okay, this additional info only. So that's a jurisdiction. So you need to know which jurisdiction. Okay, now it's a small case study. One is the impact of choosing Hong Kong law as the governing law in one party is from Malaysia and other party from Singapore. Okay, let's read this together. Small one. No, yeah, A, B. Side class. It's okay. Okay, so two universities form a partnership. One Malaysian university, another one Singapore university, but they choose governing law Hong Kong. Dispute happened, then the dispute resolved in Hong Kong. So what are the disadvantages for both universities in choosing Hong Kong as the governing law? What do you think? So both parties need to fly to Hong Kong. Then they need to appoint Hong Kong lawyer. And we are not sure we understand how the Hong Kong court system operates. So why you want to trouble yourself? Right? Why I'm telling all this? I mean, when you see the ecosystem for 10 years already, all this I'm facing. Sometimes, like out of suddenly another country governing law is in the MOU. No, it's no. Okay, whatever I'm doing today is all from my experience. So I'm just sharing. Okay, so like those are the things we need to analyze before we choose other countries' law. Okay? Definitely you cannot go by yourself. You need to bring your lawyer together. Lawyer daily recharge their allowance. Then you must give a decent hotel. we don't understand. So those are the troubles. Okay. Advantage. I don't see any advantage. Yeah, because like it's just awareness now. We still that this problem I'm seeing this very okay. Okay, now assignment we know ready. Assignment means you are assigning rights and responsibility to another party. Amendment we know ready. We can amend. Okay, after we sign, is not that we have a room to do amendment if there is a changes, but provided you have that clause in your agreement. Okay, now dispute resolution. What is dispute resolution? Dispute means both parties cannot get along, fight already. Okay, dispute started with fight already. Okay, now sometimes you will come across negotiate between the parties, or some people will put there mediation. Some people say let's go for arbitration. Some say litigation. Litigation means straightforward resolve in a court. Litigation. Okay, let's see the differences between negotiation, mediation, arbitration. Negotiation means you will appoint one party from University A, another party from University B. Both parties will negotiate, try to resolve it. Okay? Both parties discuss and accept and move on. Mediation means University A, University B, they will third party will go. They come, both party come, sit, we discuss what is the best solution. That's a mediation, a neutral third party. But I won't make decision. I will facilitate between both parties because I won't make decision. Okay, that's a mediation. Okay, arbitration is formal. It's more to formal. Arbitrator will be appointed. Okay, the arbitrator will make decision after hearing both parties. Okay, what is the problem between the both parties? Arbitrator will make the decision. The decision is binding. Binding means you must follow that decision. If you are not happy, then you need to appeal in high court. So arbitration decision is a powerful decision. Still you have avenue, not happy, file in high court for appeal. High court will decide. High court will open your case again. Then they will hear. If they say no, go with the award, arbitration award. Then you have to follow. Not happy, then do the appeal processes. Okay. Then litigation is a court will resolve. Okay. Arbitration, litigation, which one is cheaper? Okay. Arbitration, litigation. Arbitration, okay. Arbitration, litigation is cheaper. Going to court is cheaper. Arbitration is very expensive. Arbitration is very expensive. Better go to court. It's cheaper. You need to pay by hourly to the arbitrator. Sometimes you need to pay everyone. It's very costly. Construction companies, they don't go to court. Is arbitration mainly for construction? They like to go to arbitration because court will capture in the system. So arbitration is So they like to go to arbitration. Okay, force majeure. Dr. Kennedy already explained. I don't know whether I pronounced this correctly or not. Okay, is that just imagine COVID. God of act of God. Okay. Okay, now we must know the differences between binding, non-binding, and legally enforceable. Okay. Binding means party obligated to fulfill the terms. Okay. Non-binding means not obligated. Legally enforceable means, okay, who have noticed in our MOU, some of the MOU, even though it's non-binding, certain clauses they say is legally enforceable, confidential remark. Who have come across such? The entire MOU is non-binding, but confidentiality trademark is legally enforceable. Means only the two clauses are legally enforceable. The rest is not enforceable. Can you understand? Okay.
Okay, so basically the whole thing is not binding, but we cannot simply use the logo of trademarks, right? That's
Yes, yes. If everything is not binding means then they, whatever confidential information you share with them, they will share with other third party. So we must reserve the confidentiality and also the trademark legally binding. So I only remember one slide to know what is the differences between LOI, MOU, and agreement. So now the difference between these three, LOI is non-binding document. It's just a letter. It's a non-binding document. It's outline your preliminary understanding between both parties, the early stages of discussion. Okay? See, the legal status of LOI is not binding, but certain clauses, confidentiality, dispute resolution governing law can be legally enforceable. Later I will show our MOU. Even though it's not binding, we reserve confidentiality, IP as a legally enforceable. So, because any dispute happen, they use our logo, then we can go after them, we can sue them. But the rest of the clauses are not binding. Even they never fulfill their responsibility, we cannot do anything because it's not binding. Particularly, if you confidentiality dispute resolution governing law, we mentioned legally enforceable means it's legally enforceable. MOU is a document outline your intention. The legal status generally is not binding unless otherwise stated. There is a binding MOU also. Not necessarily all MOU is not binding. There is a binding MOU because some companies they want to enter into a MOU. Okay? So unless you want the MOU to be binding, it can. Okay? MOUs may include binding provisions Actually, it's depend on the parties. What are the terms you want to include in your agreement? There is no rules or guidelines what you need to include in your terms. There is no right or wrong. Provided both parties agree with the terms and conditions, sign. That's it. Okay? You can sell. See, there is a statement. You can sell a fridge. You can sell a fridge to a Eskimo. You know who is Eskimo? Eskimo, you know, the person who is staying in the North Pole or South Pole. Do they need fridge? Do they need fridge? Why? Because they surrounded by the ice, right? Eskimo. Yeah. They don't need, but you still can sell if they want to buy. You still can sell. Okay? That's the simple as that. No a strict rule. Oh, this one you need. No, it's depend on the parties what they want to do. Provided you need to know, okay, you're protected. So you need to check with your legal people whether am I protected, all the clauses are okay if we sign. Okay? And one more thing, okay, can we sign an agreement? Example, to kill a person. Why? Is the agreement valid? Definitely no, because that's illegal. So, what I'm trying to say is you can sell a fish to an Eskimo, but you cannot sign an agreement to kill a person because, see, which one is legal or illegal, so you need to know the difference. Okay? Next. Okay, another threatening word, addendum. Addendum is another threatening word. Right? So we need to know the differences between, okay, when we need addendum. When we need addendum. Okay? So we must know the differences between addendum and supplemental agreement. See, addendum is just a modification. It's just you already signed MOU. Addendum is just a modification of that MOU. For example, you sign the MOU to conduct a 16 hours lectures. But now you cannot fulfill the 16 hours. You want to make it to 10 hours. So then you come out with the addendum. Because to conduct the lectures is already in the original MOU. addendum. Supplemental agreement is totally you want to enter a new term. For example, that MOU only for the 16 lectures only. Okay, now you want to add workshop. You want to add workshop and also visiting. It incur additional cost. It's totally new, right? New term. Then you need to come out with a supplemental agreement to the original MOU. Okay, let's see this case study. First one. See the first one. University, UCSI University entered into a contract with supplier to supply laboratory equipment for new science building. But the original delivery date is different. Now UCSI University want to change the delivery date. Okay, so delivery date. So addendum or supplemental agreement. Addendum. Second case study. So the same scenario, but after a year, UCSI University decided to expand its research program and needed additional laboratory equipment which was not part of the original agreement. Supplemental agreement. So it's totally new, right? Supposed to be the new, they need to sign a new MOU. If the purpose is different than new MOU.
But so far from this one, they said we should make a tender.
Sometimes they override legal
So that we follow what?
top management. Okay, now common mistakes. So what is the common mistakes? Okay. Common mistake, what we usually do is, one is governing law, not specifying governing law, and then no termination clause. Okay, no termination clause or no notice period. Okay, term, no duration, like you never specify how long the agreement is valid. And then missing agreement date. Everyone will sign the agreement but never did. Okay? That's a common problem. Okay? Okay, next question. Usually everyone will ask, we need to stamp the document or not? Yes. Okay, why? Yes, why? To verify. Validation. Okay, legally binding. Prof, do we need to stamp? Is it compulsory? How about Dr. Benedict? Do we need to stamp? The agreement, is it compulsory?
It is better to stamp because it authentifies the legality.
Okay, how about you? Okay, just understand this, whether the agreement is stamped or not stamped, it's still valid. Okay, agreement stamped or not stamped is still valid. But any dispute happen. When dispute happen, it will ended up where? Court. If you want to bring, dispute happen after 2 years. 2 years. Now, you need to submit all the evidences, right? The agreement is one. When you need to submit that document, you must stamp. Because court will only accept stamp agreement. At that time, when you want to stamp, you need to payment. You can stamp. Your agreement is still valid. But you need to submit to court. At that time, you need to pay penalty and do stamping. Penalty is for not stamping. Late stamping. Late stamping. You can stamp. Even after 10 years or 20 years, still you can stamp. But you must pay penalty. Your agreement is still valid. Yes. If you have confidence, your partner is good, they don't need to stamp. Like most of our MOUs are now stamped, agreements also we don't stamp. Only during going to court time we need stamp. But we need to pay the penalty. Okay? Is the penalty higher than the stamping? 100 ringgit per year. Your penalty together with the stamping cost. Stamping is general MOU is 10 ringgit. If agreement with payment term, they will calculate based on your payment percentage. They will calculate percentage. 3 months to 6 months duration is 50 ringgit your penalty. After 6 months is 100 ringgit. LHDN, if you appeal 100 times also they will ask you to pay penalty. They don't consider you because LHDN definitely they need money. Recent case, GEO say they submitted document for us to, they want to stamp. General technique. More than a year, we are keep on asking them. Instead of 50 ringgit, yesterday they paid 550 ringgit. register under the Act 555, legal person. She is the legal person of the university, not me. People will confuse because some of the documents, especially for the research grant, they will ask who is your legal person, not me. That is. Who is the witness? Witness, we know the person who confirm, okay, this Parveen signed the agreement. But the witness must present when Ms. Parveen signed. Okay. Okay, now next is language. Sometimes we will enter into a other country like China, Arab, like Indonesian partner. Okay. And then the agreement or MOU will come in a dual language. So which language should prevail? You must pay attention on that part. Sometimes they will put any dispute, Chinese language will prevail. But we are not familiar, right? So we must make sure English is prevail. Okay? Otherwise, the court cannot accept the English version. Okay?
So if they insist on the Chinese version,
Cannot. We must cannot. Then we cannot get along with the partner. Then we cannot sign. Liability. So if the witness, they only witnessing the person's sign. If they not witness, they just simply sign. Then if anything, sometimes the court will call them as a witness to testify whether this person signed the agreement or not. So if that person is not during the signing ceremony not present there, then they lie, then it's legally wrong. No, the only witnessing person signing. It's not a liar. The content, no. Okay, I will finish my first part. Any question on the first part? Any question on the first part? Second part will be very short. Is that interactive? No. Lunch break after the activity. During the renewal time, sometimes scope will change. Yes, yeah. Yes. Because when we initially sign, we want to have some, something to fulfill. But when you review it or you never do this activity, then you want to exclude it. And duration part also, maybe you feel, okay, this time we go for longer partnership. Up to the parties. No difference. So always up to the parties. Any question before I go to university governance? Or all is clear?
Yeah.
Clear? You did break. Can. Toilet break, right? I'm so sorry. Okay, can. 10 minutes. Then we'll see university governance. Then we break for lunch. Okay. I'm so sorry.
Together
make the temperature higher, right? So cool.
IP 14 representation and warranty. If anything, any due diligence goes wrong, the company lied to you, they are legally allowed to sign. Anything goes wrong, then we can go after the company. Okay? So we can add more governing law. We can add governing law and also dispute resolution. We can add. So those are the fundamental. Must be legally enforceable. Okay? Okay, understand? So now university governance. Okay. Private universities are governed by Ministry of Education or Ministry of Higher Education? Higher Education. Okay. And the governing law, Private Higher Educational Institution Act 1996, in short we call Act 555. Okay? Our current Minister of Higher Education. Okay, it's the Ministry of Higher Education address. Okay. Under the Act 555, Section 30, the heading is Constitution. See, subject to the provision of this Act, every private higher educational institution shall be managed in strict accordance with this Constitution. This is UCSI Constitution. It is created in the year 2008. Okay? So the original is in legal office. See, the Constitution cannot be amended without the prior approval of the Registrar General. It's not the Registrar of UCSI University. Registrar General means Ministry of Higher Education Registrar. Okay, must get their approval before we amend the Constitution. We must get ministry approval. We must inform them officially we want to make an amendment. See, under the Section 30, the Constitution shall not be amended without the prior approval. Once they approve, then we can do the amendment. So after amendment, we must submit to them for approval because they must approve. Because each pages, wait, I'm going to show you.
other people know every single thing about it. Is there any potential
I wouldn't answer now, but all this will be keep as confidential. Okay. I can find answer for you. Okay. Okay. What is the function? Okay. Now, Act 555 clearly say each university they should have constitution. Constitution is the document will outline the governance. Okay? Governance framework of the university. Okay. VC, what is the VC function? Deputy VC, what is the deputy VC function? Senate, who are the Senate members? UC, what are the roles UC members? Okay, academy, everything, the operational part. Okay, so constitution is the important document for the university. Okay. Under the Act 555, okay, this is the Act 555, Section 31. Okay, appointment and registration of chief executive. Okay, every private higher educational institution shall appoint chief executive. Okay, a person appointed as a chief executive shall be registered under this act. So that's why VC is the legal person for the UCSI University, because her name is registered under the Ministry of Higher Education. Okay. Next, Deputy Chief Executive. Duty of Chief Executive under the Section 33 of Act 555. The Chief Executive shall subject to the provision of this Act. Act means Act 555. The Constitution, because Constitution is the fundamental document of the university, right? We also have our Constitution. So the Constitution of the private higher educational institution exercise general supervision over the arrangement for instruction, administration, day-to-day affairs, welfare, discipline in the private higher educational institution. Okay? So, our chief executive is Vice Chancellor. Okay? Is the legal representative of the university registered with Ministry of Higher Education as per the Section 31 of the Act. The Vice Chancellor of the university is authorized. She is the only authorized person. I'm sorry, LOI. LOI is between the party. MOU. Is the authorized person to sign MOU of any agreement related to university. Okay? Related to only university. The rest, Dr. Peter will sign.
So that this LOI can be signed by any officer of the university, but MOU, LOA must be signed.
So that's why we need to go to TMM. Because before TMM will make decision officially whether to sign or not to proceed with the MOU agreements. Now, back to UCSI University Constitution. Okay, Chief Executive. This one is our constitution. See, Director is the company director. Company directors. UCSI Education Sedia Berhad. Dato' Indati. No, we don't have for the university, it's a university council. The highest authority for university is university council. For the university, highest authority is the university council. Board of directors, because the university owned by a company, right? So board of directors are Dato' and Dato'. Under executive Sendirian Berhad. Sendirian Berhad.
So in a way, because the company owns the university, the company has higher jurisdiction and can tell the council what.
No. Council is the highest authority for the university. Directors is the owner of the university.
Maybe we can explain about their respective authority and
Okay.
job scope.
Okay.
Yeah.
Okay. Directors are they are the owner, own the university. Being an owner, they have an interest overall in the university. University council will overview of the operation of the university. Like academic wise, operational part.
So the board of directors, can they override the decision by the university council?
University council is the highest authority.
So they are autonomous in that sense.
So that's the name of such person appointed as chief, because under the act we have mentioned, the act is mentioned the chief executive, right? So the chief executive may be known as vice chancellor or president. Some of the university call them as director. So like we choose as a vice chancellor. Okay, the chief executive shall be responsible overall the administrative, academic management function of the university, shall exercise function duties provided in the act, including general supervision, overall the arrangement, instruction, all this under chief executive duty, which is VC's duty. She will act under the direction of the university council.
So if you amend the statute, you still don't need to vote.
No, this one is our university council.
Yes, so statute doesn't.
Statute is under ministry.
CSI has our own statutes.
Oh, okay. Yeah. But I'm not sure what the statute, because we usually use this council constitution to review. Statute, in the statute I found that mainly on academic programs.
I think the statute talks about different components. Like we have a statute on the institute, statute of various things. But it's not the constitution. Statute is not the constitution.
Statute is different from constitution.
Okay, so if there's amendment to the statute that requires us to write the constitution.
Oh yeah, amendment yes.
No, it's a statute, not the constitution.
Yeah, not the constitution.
Both also. Constitution also we must get permission. Statute also we must get permission. Whatever, because like both are approved by ministry. MOA or MOU? Yes. Only the deputy. Under our constitution, only the deputy. See, if for any substantial period, chief executive is unable by reason of illness or leave of absence or any other cause to exercise any function of his office, the deputy chief executive, if there is more than one, like in our case is more than one, we have two deputies. One is Dr. Ruhana, another one is Professor Dr. Mam. So, like she can nominate either one, but actually the nomination must be approved by UC according to our constitution. It's legal, right? But it's never right. Being chairman, maybe he signed everything, like proof. So to exercise, it's a lesser, what do you call ranking wise? Yeah, I think it's clarified now that it's only two. I think they are the ranking was yes. So the road is not. Yes, we need to combine. Yes, we need to combine. Because it's 2008, right? And we have expanded a lot. Okay. So actually, I only touch very fundamental part which is really relevant for the MOU because who can sign in the absence of the two DC. Another person can sign because those questions is always asked by everyone. Who is the authorized person? And then sometimes they ask also why DC use and why I cannot sign. So why DC sign under the Act? He is registered in the Ministry of Higher Education. She's the only authorized person to sign. In her absence, her deputies. Okay. Any question? Whatever question, I cannot answer the question.
Is the VCF authority to assign anyone lower than the VC to sign on behalf? Cannot.
Because you, constitution
So it's
say
restricted.
actually this has been answered by EMF, where somebody can remember somebody signed in place of his and the answer was no. She can sign unless she never touched the justice. Witness can be any person who
It is different.
Okay, actually, witness can be any person who witness VC sign the document, but provided that person from UCS University. And but here, EMN direction, witness must be Dato' Rohana. If research element involved, Dr. Prof. Dr. Mam. But if you ask me, witness can be anyone.
Actually, there are exceptions. There are exceptions. As needed.
No issue. I don't understand why they want witness to be deputy. So that's their direction. I don't want to be more in their decision, but it can be anyone. There's no issue.
And in the event that there's a change in signatories, and the term of the MOA is, of course, is already stipulated, then will there need to be a resigning, or is it still like